All right. Any argument, Mr. Bolden, on behalf of the state with regard to this motion? Well, actually, it is, you know what? It's Mr. Cruz's motion. I'm going to start with him. Mr. Cruz, any argument with regard to your motion?
I do think the state has the burden, Your Honor, so I do think I have the ability to go first and last, but I would waive and reserve last word.
You're right. You know what? You're right about that.
It's been a long day, Your
It
Honor.
has been a long day. Okay, you're right about that, but you're waiving anyway. Mr. Cruz, any argument about your motion? Thank you.
Absolutely. In regards to the RSID test, Your Honor, well, let me start with the law. As the Honorable Court is aware, under OCGA Section 24-7-702, B1 through 4, and I will specifically address B2. The testimony has to be based upon sufficient facts or data. Ms. Lycon's testimony is that she didn't have any underlying facts or data regarding the swabs, only that the information that she had was that it was packaged up as oral swabs. She advised that in regards to the RSID saliva test, that not only would it test positive for saliva, but it would also test positive for sweat. And the state did not take any steps to eliminate that sweat would have been a cause of the positive test. As the Honorable Court is aware, a witness testified that Ms. Baker, and I believe it was Mr. Falzone, but I don't want to stand certain, but I do believe it was Mr. Falzone, stated that Ms. Baker was alive for a period of time before she passed away. Obviously, as the Honorable Court is aware, sweat, it'll draw on your body. If you're sweating down in your mouth, it'll go in your mouth. But the state took no steps to eliminate for the RSID saliva test that is something other than sweat or saliva, Your Honor. Also, she stated that this is a presumptive test. We heard testimony from a DNA expert, I believe it was yesterday or the day before yesterday, that talked about the importance of confirmatory tests. This is a test that simply indicates the presence of a substance that could be consistent with, again, sweat or saliva. And again, she didn't have any facts or underlying data to make the determination of whether either one is or which one is present. Additionally, and I think most importantly, and this may go to another factor as opposed to two, I believe this one goes to B as a whole, she's admitted that she has never testified or been qualified as an expert to testify about Lugo's iodine testing. As the Honorable Court is aware, when it comes to the type of science that's admitted under Daubert, it is a higher standard than the Harper standard. And here, Your Honor, I found no cases where the Lugol's iodine test has been accepted in the court. And I could show the Honorable Court, we could do a search on Westlaw, but I found no cases where a court has admitted it. And even Ms. Lycone states she's never been admitted as an expert to talk about the the RSID saliva presumptive test. So that would be my request to the Honorable Court in regards to the RSID saliva test, is to exclude it based upon saying it is not a set in stone science. It sounds more so like it's indicative of multiple different things. There's no way to confirm whether or not it's saliva. It's just a presumptive test, as she stated, that indicates the presence of the item. In regards to the Lugol's iodine test, she stated that the urethra of a penis could stain chocolate brown. She stated that buccal cells could stain dark chocolate brown. And she stated that there was no specific way to know whether or not the cells were penile cells or vaginal cells, except for just looking at the number and determining whether or not 10% of the cells stained positive. The state presented a picture that included dark brown cells. However, the state at no time elicited testimony from this witness, and it's their burden, that established that that was more than 10%. The Honorable Court didn't hear a number. We just saw a picture. It's a lot of cells. Some are lighter colors than others. So we would ask in regards to the Lugol's test, because we can't differentiate what's what, and the only basis that she has in regards to determining what the what the substance is just saying that it indicates the presence of the substance, Your Honor. But I think the biggest issue we have are 2 points, and I'll make it simple. The biggest issues we have, there's no confirmatory test. She stated there's no confirmatory test on this. We don't know what this substance is. We don't know if it's for the Lugol's, we don't know what the substance is. The second one, Your Honor, it's never been admitted. The state has presented no evidence that this type of testing has ever been admitted in a Georgia court before, in a criminal case or a civil case. So I would ask, based on those grounds, the Honorable Court excludes the speculative science of the presumptive test of the RSID saliva test, as well as the Lugol's iodine test. Thank you so much for your time, Your Honor.
Thank you. Mr. Bolden.
Your Honor, I'm going to try to be brief. I think we've been going at it all day, and I don't know that if I can approach.
Okay.
I won't speak for Mr. Cruz, but I'm going to try and, it's hard to stay focused after such a long day, so I'm going to try and be brief. I agree with Mr. Cruz that I did not find a case anywhere in the country that stands for the proposition that the Lugol iodine test is admissible under Daubert. I don't know that that's ever been considered before. I don't know if the court may well prove me wrong, but I did look. But I handed the case of U.S. v. Brown. I had a copy for defense counsel and for the court. This is an 11th Circuit case. 415 F. 3rd, 1257. It is a 2005 case. And I won't get into the type of expert testimony that the government intended to offer or did offer in that case because I didn't understand it. But there is some just really interesting language about Daubert in general. And I'm going to direct the court to if you go to the second column of page 10 of the printout that I just handed you, first stands for the proposition that evidentiary decisions are reviewed under an abuse of discretion standard, and then the 11th Circuit goes on to say that they defer to district courts on evidentiary rulings for a handful of reasons. One is that difficult evidentiary rulings turn on matters uniquely within the purview of the court, which has firsthand access to documentary evidence and is physically proximate to testifying witnesses and the jury. Being at the trial as the proceedings occur and the evidence unfolds, a trial judge has an advantageous familiarity with the proceedings and that may not have insights conveyed by the record. That goes on to page 11. The 11th Circuit goes on to say that the second reason they give deference to a trial court is because it is not possible, and this is the second paragraph on the left column of page 11, it is often not possible to precisely calibrate rules for many different circumstances that can arise. It goes on to say that this is a case-specific, detailed, factual determination. The last paragraph talks about how this abuse of discretion applies even more in the areas of Daubert. It says that's where it actually, the language is wonderful. It says that the review of evidentiary issues are even greater in Daubert issues because that is where the abuse of discretion standard thrives. The trial court is familiar with the facts and details of the case, and the task of evaluating the reliability of expert testimony is entrusted to the trial court. There, the 11th Circuit found that only one of the 4 Daubert factors were met, and they said that the question then is whether expert opinion evidence that does not meet 3 of the 4 Daubert factors nevertheless can be admitted. In the right circumstances, the answer to that question is yes, and I'm on the middle of the right-hand column of page 12. Goes on to say that the inquiry envisioned by 702 is a flexible one. I'm almost done quoting the case. On page 13, the district court found that test and the court can obviously probably read better than I can at this point about the type of witnesses that the government had tendered as experts, but that their expert opinions were based on their knowledge, skill, and experience, and based on sufficient facts and data, and there was no abuse of discretion. I do point out, lastly, at the bottom of the left-hand column of page 13, that the trial court has not just a heavy thumb, but really a thumb and a finger or two on the scale of admission of evidence under Daubert. And so I point all that out to say this. I think that what Pure Gold was asked to do, and I think that what Ms. Lycon has testified to tonight needs to be considered in the circumstances of the facts that the court already has before it. So Dr. Falzon testified that he collected oral, vaginal, and anal swabs. We tendered the swabs that are in evidence, and in case the court has forgotten, the whole issue here is that an X was labeled on an oral swab that was really a vaginal swab. That is the state's position. That has always been the state's position. Dr. Falzon testified that all 3 were collected. He testified that, and we have in evidence, vaginal, oral, and rectal smears, which he testified that a smear can only be created from a swab. And I'd go one step further, and I do think that the court can, in fact, take judicial notice of evidence that was tendered in the Daubert hearing related to true allele, because the state did, excuse me, the state did at that hearing tender the results of true allele. And if the court may not remember, but I can state in my place, that item 2I, which is what the state contends is the actual oral swab, only has the DNA profile of the defendant, Mr. Faust. Item 2J has the DNA profile of Chris Melton and of Edrick Faust. So they're not the same. So when you look at all of those factors, you look at the tests that Ms. Lycon described, which I would argue are based on scientifically valid theory, that they have been subject to peer review, and so at least 2 of the Daubert factors have been met. Based on sufficient facts or data, it is the product of reliable principles and methods. I do think in this context, especially when we are only asked to determine a very limited question, not just are these the same or are they different, but which one is more likely to be an actual vaginal swab? I think that the state has met its burden as it relates to Daubert, and I would ask that the court allow Ms. Lycon to testify at the trial to that effect.
Thank you, Mr. Bolden. All right, with regard to Mr. Cruz's motion, the first thing I want to emphasize is that the court has already allowed Ms. Lycon to be admitted as an expert in the area of forensic chemistry and forensic biology. With regard to 702, I'm making a finding that the state has met its burden, and I'm making a finding for these reasons. First, it is obviously very clear that this expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. I mean, that's just clear. And anyway, I'm not going to say any more about that. I think that you can't really argue with that. Number two, the testimony is based, and this is under 702, the testimony is based upon sufficient facts or data. The argument that the defense has made about factor number two not being met because the evidence that she received may not have been sufficient is actually not what number two is about. The testimony that she provided was that she tested what she got, and whether the pieces of evidence that she tested were sufficient is a matter of weight. It doesn't actually go to 702. And so I'm making a finding that number two has been met. I'm going to jump to let me go to number three. I think number three is the one that we're sort of arguing about. The testimony is the product of reliable principles and methods. Certainly, Mr. Cruz is making an argument that the state acknowledged that certain of her testing has never been accepted, or admitted, I should say, not accepted, admitted in a court proceeding. And that the reason that number three has not been met is because of that. And certainly there is, that is an interesting argument, and it's important to consider. The trial court does, however, have the power to, I shouldn't say the power, the authority, the discretion, that's the better word, the discretion, to use, and we've heard this phrase many times today, the totality of the circumstances in making a decision as to whether any of these factors have been met. And the totality of the circumstances is that this witness is relying upon principles and methods that have been in existence for a very long period of time, that they have been peer reviewed. But I think most importantly for this moment is that it's just acknowledged, and the testimony has been, that these results are presumptive. And I think that lends a different lens to this particular case. And so I'm making a finding that number three has been met based upon the testimony that of this witness, that her testimony about her results is in fact presumptive. And I think that nuance is crucial to this determination. And number four, she has explained that she has reliably applied those principles and methods, whether they are accepted or have been accepted in a court of law or not. She has applied those principles and methods to the facts of the case. And so the factors I'm making a finding in 702 have been met. Most of the argument that the defense has made goes to the weight of her testimony. Certainly the issue of the weight of her testimony, the credibility of her data, of her testimony, of her analysis, is certainly open for examination. And I'm not making a finding on those particular things. I will say also that another reason why the court is finding that factor number three has been met under 702 is because the thought just went out of my brain. Hold on just a minute. Let me think of what I was going to say. It's been a long day. I need to come up with this. Hang on a minute. I don't remember what I was going to say, so I'm just going to scratch that from the record. Anyway, I'm making a finding under 702 that the factors have been met by the state. The burden has been shown, and I'm going to deny the motion to exclude the testimony of this particular witness, Ms. Lycon. And that'll be my findings. And I hope I remember what I was going to say. I'm not sure I can. So, all right. We are going to meet here tomorrow at 8:30, and we're going to go over Mr. Peterson's address the motion with regard to Mr. Peterson. Am I right? Is there anything else we have to take up?
Nothing from the state,
Okay.
Your Honor.
Mr. Cruz, anything else, sir? All right, then court is adjourned, and I will see you all tomorrow at 8:30. Mr. Cruz, I have a note for you from our court administrator about the room to store your things in. If you want to come up, I'll give it to you, and you can take this with you and do all that. Other than that, court is adjourned.